Friends, Romans, countrymen. I have missed all my e-friends. I feel like I've spent the last 2 years being aggressively burned out but not really recharging, so I've kind of taken the last couple months to just sleep, literally and figuratively. Anyways, hi, back to talk about laws. I'm streaming with Jackie and Dr. Jordan this week. Hopefully this will come out before that, but we're going to talk about the abortion decision that is pending. So I figured this is a good excuse to jump back in with my own stuff and talk a little bit about the Melissa Lucio death penalty case, which was just stayed. It was a federal death penalty that was going to take place in Texas, which is, even though it's a federal case, it's still a Texas jury, Texas law enforcement, so, it's not an accident that it was Texas. But Melissa Lucio was scheduled to be executed on April 27th, and there was a lot of pressure from both sides of the aisle, actually, to stay that execution. The Texas Court of Appeals actually granted that 2 days before the scheduled execution, so on 4/25. But that doesn't mean that it's over yet, because it just means the case goes back down on what's called a remand. So let's start here. Melissa Lucio was charged with and eventually sentenced to death for capital murder. She is the mother of 14 children. Not her youngest, because she's actually pregnant at the time of her arrest with twins, but her 2-year-old daughter Mariah died from blunt force trauma, was the autopsy finding, purportedly after a fall down the stairs, according to Melissa Lucio and her family, so the other children who were there. But she was charged with not only, when you hear something like that, you could think, okay, maybe child abuse, maybe neglect, maybe any number of things, depending on the evidence. But she was charged with capital murder while pregnant, and then eventually was convicted and sentenced to death for capital murder of her daughter. So the problem there, even if you take issue with some of the specifics of her parenting, corporal punishment is something that I personally don't really ever support, and that does come out, that she spanked her daughter and her other children, and that may have been hard enough to sustain bruising from. It's neither here nor there, because we're talking about, does this justify a capital murder charge and a sentence to death, which are two massive things, and it's kind of, don't get distracted when we're talking about this by, maybe I don't agree with this choice. The difficulty and the thing that makes mistakes in this arena so easy is that prosecutors and people on the side of the death penalty can distract pretty easily by pointing to any flaw. But remember, this isn't, is this person perfect? It's, do they deserve to die for what they did at the hands of the government? So the problem with the charge and conviction is that they're based really on loose, weak, very susceptible evidence. And there really was nothing too concrete to go on. So we're going to go through the interrogation and eventual confession circumstances in more specific terms later, but the long story short is that Melissa Lucio did confess to causing bruises or causing injuries on her daughter after she had been interrogated for many hours and had previously denied any involvement. So she didn't actually even confess to, I killed my daughter, and it was also under potential duress, if you consider threats that maybe were true to be duress. Anyways, we'll get there. But one of the interesting things also is that there were no Child Protective Service reports of any violence committed by Melissa Lucio against her children or otherwise. Also, her other children didn't report anything violent from her towards any of the kids. And she wasn't alone with Mariah in the applicable time frame if she was responsible for her death. So none of the kids who were with her reported that she was alone with or violent towards Mariah. It's also interesting, and some of these things didn't come out at trial. Some of the protective evidence didn't come out at trial, and some of the evidence that did was very susceptible, so you kind of got a two-pronged issue there. But there is an alternate theory, and I'll touch a little bit on it later. I don't know too much about the specific evidence, and so I feel like I should refer you to other sources for a better account. Like NPR has done some great coverage of this case. There's a good documentary, and of course, I think it was like a 2021 on Hulu about the case in depth for like the facts and evidence and where it stands. But the condensed version is that there are two compelling alternate theories for how Mariah sustained the injuries that led to her death. And of course, the standard in any criminal trial, and certainly one for murder and that involves sentencing somebody to death, is that there is no reasonable doubt. There's no room for reasonable doubt. So two plausible theories, especially ones where the evidence didn't really come out at trial, is very concerning. So one is that Mariah fell down the stairs and, bruising, even head injuries, consistent with falling down the stairs, and it does make sense. A parent of that many children, an accidental situation like that is tragic, and it also is plausible, but it doesn't constitute capital murder. Another theory, which is actually documented as being cited by one of the other kids by the social worker who interviewed some of the kids, is that one of the other daughters, Alexandra, had a lot of bitterness towards the little Mariah and had a habit of hitting her and treating her very aggressively. And so there was actually documented evidence on the day of Mariah's death of somebody telling the social worker, "My sister Alexandra beats her," and also saying to the social worker, "Don't tell anyone." So that, to me, is pretty compelling evidence of another potential alternate theory that didn't come out at trial. In any case, let's go through the procedural history really fast up top. Again, if you are super interested in the specifics, I'd refer you to other sources that have done a much more in-depth point-by-point of the case. But we have the original jury trial and sentencing, which death sentences need not only the original conviction of the underlying crime, but a jury also has to approve the sentence to death. So this is where, I mentioned up top, it's a federal death penalty case, which is less common, but also we're talking about a Texas jury, and that is less surprising when you have that. There are some questions about adequate representation of counsel, and this is always such a tough thing when you think about pro bono defense representation and stakes being this high when the death penalty is on the table, because there's simply not a lot of funding and resources for pro bono attorneys. So oftentimes, if you get a public defender, which usually is the case for low-income people, for low-income defendants especially, it's risky. They may have tens on tens on tens of cases in front of them, and they may not, have the physical energy to devote to any one case, regardless of the stakes, because you're human. And that, even though it is an adequate representation of counsel problem, it's not even necessarily reflective of the lawyer themselves, because we ask a lot and don't throw a lot of taxpayer dollars at these people, especially in Texas, which tends to be a low tax state. But obviously in some of these decisions, in terms of, are we bringing out alternate theories, there's a question about should counsel have tried to suppress the confession up top before the trial even started, because there were decent grounds to do that, which come up on the appeal. So a lot of those things are not only substantive factual issues, but it's also like, hey, the procedure in the original trial was so messed up that we got to redo it. We got to go back and do it again, especially, again, when the stakes are so high that the government is considering taking someone's life to punish alleged taking of life. It's a fundamental problem. I should refer folks, if you're interested in the law, constitutionality, history, jurisprudential nonsense behind the death penalty in more depth, we on Exceedingly Persuasive, so Brooke Rogers and I actually covered that in a 2-episode arc. Back last year, I believe it's episode 40-something, I'll put it at the end, but it's 2. One is Kill versus Maim, shout out to Grimes, who sucks a little bit now. And the second one is with Kat Timpf, a friend of ours, who tends to be more libertarian, but we do come together on the death penalty issue. But if you want to go through some of the specifics on ethics and jurisprudential morality and stuff on that, you can listen to those. So then finally we get to the stay application, which is the under-the-wire last-minute appeal attempt that's like, execution is scheduled, and this is what happened in April. There are huge problems with how this decision was reached. Please, state, hold off so that we can look at these grounds and maybe redo it, because once somebody is executed, you can't go back. I mean, at the very least, if somebody is incarcerated, which like, this isn't good. And the flaws in the criminal justice system are why we don't want to have unerasable stakes. You know what I mean? But at least if somebody's incarcerated falsely, even if it's for decades, if they're still alive, they can have another shot at life in some sense. But execution tends to be pretty permanent. In any case, so that was granted on the 25th of April, 2 days before the scheduled execution. They talk about adequate representation of counsel, which we talked about. These are the grounds for the stay, and to overturn the trial and send it back to redo it. So it was representation of counsel, new medical and scientific evidence that was not available during the first trial, so new stuff. Also, Sixth Amendment violations, which is the right to counsel. During the interrogation, she didn't have a lawyer present. That's one of the things we're going to talk about later in this episode. Like when that right attaches, how you waive it. It's not as intuitive as you'd think, and a lot of the lines are ones that can be undrawn if somebody says the right thing. And of course, people don't know this when they go into something, which is why people say don't say anything, because you might actually be waiving a right without even knowing it because of some weird Supreme Court decision. So anyways, you got Sixth Amendment violations alleged also. A Brady violation, which some of you may have heard if you watch like crime procedurals like SVU. That's the Supreme Court case that requires the prosecution to hand over and reveal any favorable evidence to the defense so that they have access to everything, because prosecution is usually affiliated with law enforcement, so they have access to more records, and it's every criminal defendant's right to know what helps them and not have that hidden from them and from the court. So Brady violation was alleged that favorable evidence to Melissa Lucio was suppressed and not shown. Then there's also an allegation of false evidence. Again, I don't know the specifics on some of the evidentiary minutia, but I'm sure it's out there. And then finally you got some juror misconduct and the allegation of actual innocence, which should always be a strike in the leniency category. So those were the stay application bases. So just to recap, the legal issues we're going to go through today, because it hits a lot of them. We've got due process in confessions, and that's kind of what process you need before somebody takes your liberty, and eventually, in this case, your life. So due process is like Fifth Amendment and 14th, depending on if it's the federal government or state. In this case, it's Fifth, because it's federal. And then you have the right to counsel, Sixth Amendment questions, and Miranda also comes up in that context. Like, being advised of your rights before you are put in a position to incriminate yourself. And then some of the death penalty stuff. So criminal justice ethics, the Eighth Amendment, which is the amendment that bans cruel and unusual punishment and disproportionate punishment to crimes. So some of the history there we'll touch a little bit on, but again, you should go back and listen to the episodes if you want the real deep nonsense. And then obviously there's the question of child neglect and abuse, and that versus death, and neglect versus active harm, which are, the law views them a little differently. And finally, because we don't always get to talk about the requirements for scientific and medical evidence, and obviously there are a lot of issues with how our government handles medical evidence in today's society, but we actually do have a pretty good roadmap for dealing with it in the legal world, which I think is encouraging, and maybe a good roadmap for how we deal with science and medicine and the legitimacy of it in all branches of government. So that's what we're going to hit today. I'll see you in 2 seconds. So we're going to go chronologically through the path that this case progressed on, that Melissa Lucio's case progressed down. We start with interrogation and confession standards, and kind of comparing that to the facts of her case. So, like I said, the first constitutional issue you hit here is due process, and that's the kind of amorphous requirement that has been clarified in many different directions, including the right to privacy, bodily autonomy context that we're going to talk about with abortion in the stream with Jackie, and probably a million more times, especially as they whittle away more. Anyways, it's the thing that says in the 5th with regards to the federal government, and in the 14th Amendment with regards to any state governments, that the respective government cannot deprive people of life, liberty, or property without due process of law. So the question becomes, in this context, what process is due? What does that mean? And it varies, obviously, depending on what we're taking and what's alleged and who's doing it, so there's no standard answer. But in this one, it comes in regarding the circumstances in the initial questioning. So Melissa Lucio was taken in to the police station while she was pregnant with twins, and immediately after her daughter had died. So I think regardless of the circumstances, you acknowledge that this is a trying time. Even if you think she's guilty of something, her daughter has just died. Her 2-year-old is dead, and she is immediately taken in and questioned and, accused of being responsible for that. So there are some questions about custody and are you free to leave? That's the first thing that comes up in a due process sort of question is, are you under arrest? And if you're not under arrest, do you know that you're not in custody? Do you know that you can leave at any time? And the treatment while you're there affects the voluntariness examination of any confession or any statements that you might make. I hope you're with me so far. So voluntariness obviously comes into play here because she's being questioned in the police station, and she does not have an attorney. We'll get to that later on the 6th Amendment front. And so not only does she not have an attorney, but she's one-on-one with police officers, she's being accused, and it's a high-stress scenario. So anything that she says, you have a hint of a question right there with the voluntariness of it, because you put somebody under those circumstances, and you assume that they probably want to get out of there. And so at what point does that become inducement of a confession? At what point does that pressure become too much from the state that it calls everything into question that is said? So confessions cannot be due to inducements, and an example of that is threats or promises. So it can't be something like, if you don't confess to this, we're going to take your kids away. So the line there is kind of like, you got to look at what is being induced. So In this case, they did make threats, if you will, and they said that if you don't cooperate and if it comes out that you're convicted of this, you will lose custody of your other kids. The tricky thing there is, A, they're not inducing her to confess. Technically, they're trying to induce her to tell the truth and to cooperate, which they think means one thing, and obviously it's implied that she should confess to make them happy. But technically they're not saying, you better say this thing, which is the key difference. It's not forcing her to confess, it's forcing her to tell the truth, which they are implying and believing is a confession. So it's different. And then the other thing is that technically the threat is not unlawful because it did happen, you know? If she is convicted of this crime, and she was, she will lose custody, and did, of her other kids. So that's where it becomes tricky, even when you have a set definition, like you can't make someone confess with an inducement like a threat. Defining what an unlawful threat is tricky. And in this case, from what I heard and saw, that piece doesn't cross the line. But the other pieces, which are even less concrete to define, are where the line is of other coercive circumstances. And this also brings us into Miranda territory, which is similar to the due process examination, but technically its own inquiry. But that's another one if you've watched crime show procedurals. You have the right to remain silent, you have a right to an attorney, the requirement that you be told about your rights when and if you're brought into custody. But, so that's kind of the advising somebody of their rights before you arrest them. But in that inquiry, we talk about some circumstances that are seen as inherently coercive, even without something like a direct threat inducing someone to confess. And the things they look at there are you in police custody? Are you, being held at the police station, for example? And are you on police territory versus being questioned by officers and not allowed to leave, which could be custody, but you're at your house. So Melissa Lucio was both in custody and on police territory. She was at the station. And this went 6 or 7 hours through the night into the wee hours of the morning. Again, she's pregnant with twins, and her daughter has just died, and she doesn't have an attorney. Get to that. But, pretty scary circumstances as a whole. And then the third prong of the Miranda Fifth Amendment sort of inquiry is who's present in the interrogation/interview. Is it just the prisoner/interrogee and the officers, or is there anybody else there? Even if it's not an attorney, is there like a social worker, a family member? The law enforcement on individual in isolation sort of dynamic is obviously a lot more stressful and a more polarized, imbalanced power dynamic. So the last thing is that obviously it results in an incriminating statement. So these would be the questions to look at in terms of the confession. Were there inherently coercive circumstances? I believe it also came out that she didn't have any food or water, which again, you take the timing, her physical state, her emotional, mental state, all into account, you get more of a picture that could require a look at the confession and whether it was inherently coercive, the circumstances under which she confessed. So that's something that wasn't looked at in the first trial, and obviously that brings the counsel assistance question into play as well, because I think any lawyer who's looking at that, hindsight is 20/20, but is going to see some arguably coercive circumstances under which she confessed. And so under those circumstances, you kind of, at the top, as what's called a pretrial motion, want to try to get that suppressed and kept out of the trial. They also did not introduce any experts who could speak to involuntary or coerced confessions, which would be, say that pretrial motion was made and failed, that would be another way to maybe inform the jury that these are circumstances that could make somebody in her shoes say something that's not accurate. Because again, I think I said this at the very beginning, but she did not confess to anything. In fact, denied until she was pushed after many, many hours, many, many questions, and there was this threat of losing custody of her kids. Which again is not an incorrect threat, but it does change the circumstances under which she said this one thing that I'm sure was pivotal in the trial. So you've also, just to quickly cover the Sixth Amendment right to counsel and when that attaches, when you get to have counsel and when not having counsel is a problem in terms of any ultimate conviction. So you don't have to Mirandize somebody, like advise them separately of their right to counsel at a different phase. And you can't bully somebody, scratch that. So you don't have to Mirandize them, which is one thing. So there's a lower bar in that sense. But let me cut this here. So there's some kind of tricky things with this right and when it attaches, and you can actually kind of have circumstances where the Sixth Amendment right to counsel is waived unintentionally. So you don't have to re-Mirandize somebody in custody of the right to counsel, which is something that kind of weighs against the defendant because any other warnings would be great in terms of the power imbalance and the dynamic that we've talked about. It's intuitive. But so you don't have to do that. Law enforcement doesn't have to do that. The one hard line is that law enforcement or whoever's questioning the eventual defendant, can't bully them into waiving their right to counsel. So, again, we're getting into a word that's tough to define, but it's that similar kind of, you can't threaten them, you can't beat them up, you can't treat them aggressively differently and more negatively if they don't waive it. But here's the problem. Even if somebody asks for an attorney, law enforcement can they can say, yeah, and they can let them call the attorney, but they can still talk to you. And this is why, if you've ever heard people say, just don't open your mouth around law enforcement, ask for a lawyer and then nothing more. It's because of this kind of thing. That even if you ask for a lawyer, if law enforcement succeeds in chatting you up, and in doing so, hey, do you want some water? Honestly, this kind of case is so tricky. Are you sure? They said it's going to be a while. Where were you earlier? And then they start spitballing questions. If you start answering any questions and you engage, that means that you have gone back and waived your right to counsel. Even if you ask for an attorney, even if they're on their way, even if they get there later, you have waived for that period your right to have an attorney present, and anything you say once they start asking you questions again and trying to keep prompting you is fair game. So that's really skeezy to me, but it is the law. And it's a valid waiver in the period that you answer any questions or volunteer anything or engage. So, good lesson for anybody who will ever be interrogated, because yikes. But it also does make this sort of thing, in Melissa Lucio's case, I don't know if she asked, I don't know when certain things happen, because obviously it's a multi-hour interview, but this is one of the things that came up in the stay application, to send it back to trial to look at when and if she should have had counsel present and didn't in this interrogation process. So, obviously, these are things that not only count in terms of her guilt and how she eventually was convicted, but also in terms of the kind of assistance she got in the first trial. So it kind of counts doubly. There's the constitutional violation, and then there's the why didn't anybody notice the constitutional violation piece. And then below the constitutional violation, there's the substantive fact that a lot of this not only did it violate her rights, but the reason it violated her rights is because these are circumstances that are not reliable in terms of creating confession evidence and things like that. So, that's that. I try to whip through the last part on death penalty in-depth legal nonsense because we do go over it if you want to delve deeper. We go over it in episodes 44 and 45 of Exceedingly Persuasive, and they're still in the feed. It's all good. And so if you want to hear, especially 44, I think has most of the stage setting stuff. And then 45 has our dear lovely friend Kat, so that's just fun. And more of the ethical conversation too. So I'm going to try to keep this short in the interest of not rehashing too much, but obviously there is the constitutional question that comes out of the Eighth Amendment. The Eighth Amendment is the one with the prohibition on cruel and unusual punishment. It has come to look at excessive punishment for the government to be instilling. And so I think that that's the best place to focus because obviously, even more so in other cases, Melissa Lucio is a pregnant mother who's arrested, mother of many kids, happened to be a victim of domestic abuse herself, and a very young mother in the beginning. So there are a lot of reasons why she's additionally sympathetic as a subject of the death penalty, but oftentimes, a reason why this inquiry is so difficult to have in a measured way is the fact that people who are facing the death penalty are pretty much at this point in our legal historical arc only going to be people who have done or been convicted of the worst things. In fact, a case called Coker versus Georgia is the one big thing that I will hit on, and that was the one where the Supreme Court said, kind of looking at punishment to crime consequences as a ladder concept. So you can't sentence somebody to the death penalty if they didn't take a life, because you don't want the punishment to be on a higher rung of wrong than the crime itself. But, even though we are theoretically only sentencing the worst of the worst, the takers of life, to death in this country at this point, the way that I like to frame it, but you got to look at it as, should the government be in the role of taking life, especially if we are trying to encourage a system where the taking of life is that bad, that there's an inherent hypocrisy to it on the one hand, and on the other, you're looking at a criminal justice system that is so deeply flawed in so many, objectively measurable ways, that until and unless we can work out those kinks to a much greater degree than we could even fathom at this point, such a flawed system that can so easily make errors should doubly not be taking life, because that is, oh god, you know what? I just wanted to quote Juno, which is kind of fucked up, but it's one doodle that can't be undid. To quote Rainn Wilson. Oh god, it's getting to be my bedtime, isn't it? Alright, seriously though. So, the current bounds of the Eighth Amendment, it's kind of this proportionality evaluation. So, save for certain aggravated child rape circumstances, you have to have taken life to be subject to the death penalty. That kind of starts us on a theoretical inquiry, because obviously the case is going back on remand for guilt, and then we'll reach sentencing again. But that means that if it's anything short of capital murder that Melissa Lucio is convicted of and or is actually guilty of, so that includes, child abuse if the corporal punishment got too aggressive, or, battery, child neglect especially, because, as a side note here, the law tends to view the absence of action, so kind of omitting to act, which is essentially the definition of neglect, a little bit differently than it does active, intentional intervention. And you can kind of see the difference there in much more exaggerated circumstances. If you think of, like, failing to jump in front of a gunman versus being the one to take a life, those are two different things. Obviously, that is a hyperbolized situation, but you can see why the law handles them differently. So if it's anything short of capital murder that Melissa Lucio is guilty and or convicted of, that means that she should not be and will not be subject to the death penalty, which that variability, and also looking how down to the wire the stay of execution and remand of the trial got, is instructive in and of itself as to why the death penalty, in my opinion, and looking at the whole landscape, shouldn't be on the table. Because if it's that susceptible, if it's that close on so many different fronts, these laser lines that literally become life and death for what comes to seem very, like, bureaucratic and arbitrary. It doesn't seem like the civilized progression of a governmental system, which obviously we're flawed, but let's keep trying to perfect what we can, right? Anyways, so even if, and this actually, because we haven't mentioned some of the scientific medical evidence that has come out, and this is a good segue into the standards there, and then we can take her home. But so looking at all these alternate scenarios, and what if she's guilty of X, so if it's just corporal punishment, and here's a new alternate theory that, as of a documentary that I believe was dated 2020, was relatively new and thus not available at the first trial, likely will come up at the remand. There's evidence that Mariah, Melissa Lucio's daughter who died, may have had a clotting disorder, which would mean that any bruising and any injuries would be much more life-threatening and potentially fatal in a way that is not foreseeable. So paralleling that to, like, what if she's guilty of anything lesser? If it was corporal punishment and clotting disorder, that changes the landscape. That no longer, potentially, all up to a jury, etc., but that might sound less like capital murder, even if you find this person guilty of beating their child in the same way. Even with all else being equal, that, she didn't fall down the stairs. It wasn't somebody else. It really was, Melissa Lucio's fault. Even assuming that, if you add this variable of a clotting disorder, which was not apparently checked for in the initial autopsy, it was just assumed blunt force trauma, bruising, cut and dried. That alone changes the landscape. So that'll bring us to the way that courts look at scientific and medical evidence. Obviously, in this case, it also comes up in terms of the effect of newly available evidence on an appeal, because that's one of the few grounds that can get you in for a new trial, because obviously it wasn't an omission, it wasn't laziness, it's not like another bite at the apple if there truly is new information out there that you didn't have before. So at this point, I'll refer you again back to any other in-depth sources, whether it be that Hulu 2020 documentary, or NPR's coverage, or any other good vetted source if you really want to dig into the evidentiary specifics. But short version, how do we look at scientific and medical evidence in general in the courts? And I do think that this is particularly relevant, even though it's kind of a big part of a tangent, even in terms of the appeal. It was one of 6 bases for the appeal and remand and execution stay, but infrequently do we have a chance to discuss how the judicial system tends to handle science and medicine. And in the wake of COVID and so much anti-science sentiment in general, and this politicizing of science and medicine, it was reassuring to me to go back and look at these standards with that context. So I feel like it's kind of nice to share that, hey, there is a way that one of the branches of government handles truth and tested information, and it's pretty good. You'll hear it. So I feel like that's instructive and maybe could be applied to legislation more, or add some uniformity to the way that we measure other things. So there are two tests actually that are used in different jurisdictions. They achieve a similar goal. In the law we call it like majority rule and minority rule. Sometimes there's a shift from one to the other. In the case of medical scientific stuff, there's the Fry test and there's the Daubert. It's spelled Daubert, but every legal professional I've known has said Daubert. But it feels really gross to say it, so the Daubert test. And it comes from a case name, so presumably it is somebody's name and it actually is pronounced Daubert, but it's ridiculous. Diubert. I would rather say Daubert standard is what federal courts use, and some state courts as well. So we'll look at that one just because this is a federal case. When you're looking at scientific and medical evidence and theories, expert testimony used to evaluate it, you got to make sure that it clears the hurdle, that it's not some like weird snake oil fringe theory, that if the court is really going to give it the credence of science, there's got to be some, you got to make your case. So here's how you make your case. There are a bunch of different prongs under this standard. First, the theory and or technology is testable and has been tested. It is and has been subject to peer review and publication. Is there an error rate, and what is the error rate? Are there controlling operating standards that exist, and are they maintained actively? And finally, is there widespread acceptance of the theory or technology in the scientific community? So I think that that's a really good way I think it covers a lot of bases in terms of scientific evidence and testimony, and I would love if other branches of government looked at things in the same way, because facts are great, and objectivity is great, and we have a codified test that we use in the law, so anyways. I just thought it was interesting to delve into that. It's not super pivotal to the Melissa Lucio case. It'll likely dictate one piece of her retrial on remand, but I think it's kind of interesting. So, obviously, this is a good point to say that in death penalty cases, you get probably the broadest appeal right out of any type of case because of the stakes, which, I hesitate to laud that standard too much, because it's like, yeah, damn, you should, because Jesus, maybe instead of the appeal right, we should just stop doing it. But yeah, so that probably is why the stay application was granted by the court, even that down to the wire. Although, hell, that would be pretty stressful. The last thing that's worth touching on here, that is probably obvious to so many people at this point that it almost goes without saying, except that it bears repeating, is this brings up a question that you have in so many criminal justice issues of the uniform application of the law. Obviously, maybe not obviously, Melissa Lucio is a low-income defendant. She had a lot of kids. She was a victim of abuse. She's Latina. She's in Texas, which, doesn't bode well for you statistically if you're facing a death penalty. And that picture changes the likely outcome of any criminal case, death penalty or not. So, again, this is a federal case, and I think she's the first. She had some dubious distinction of being the first Latina woman on federal death row or something, which, Jesus Christ, man. Obviously, if she were a man, it would be worse. But that said, I'm sure there's the the double standard of judgment that goes with mothers who have missteps versus fathers. So there are all sorts of demographic and economic, ethnic, social factors that go into how the law is applied, which is a good excuse for my final underscoring of the point that until and unless we can get a criminal justice system that is not so susceptible to pointless subjectivity. I mean, cases should have some subjectivity because things vary so much that there should be some positive wiggle room, but when it's subject this much to biases and prejudices, as can be proven by objective facts, maybe hold off. Maybe we can table the death penalty at the very least for a little while, without saying that, these people are always good or always blameless. Just, the punishment phase can be re-examined. And if you want to get more into that ethical examination, lest I neglect anything, please do go listen to episode 44 and also 45, Exceedingly Persuasive, and we'll yammer about that. So, that all said, Melissa Lucio's case is now on remand, which means she will get all these things examined again. Her execution is no longer scheduled, but she's not out of the woods. The same thing could happen. So if there are any opportunities for advocacy, take them. And the Innocence Project tends to cover a lot of similar cases as well, so always worth looking at their stuff. And presuming that I get my shit together enough that I get this out before Tuesday, please tune in for the stream with Jackie Zabrowski and Dr. Jordan that we're going to do on the impending abortion ruling, overturning Roe v. Wade. Sick. All right. Be well, be good, be safe, be happy. I'll be with my cats.